Do you feel picked on because you're older than your coworkers? Do you suspect you lost your job because you're older and because you made more money than younger workers? Age discrimination is a common complaint. A recent survey for AARP reported 64% of respondents thought that people older than 50 face age discrimination in the workplace. Some 34% said they had either personally faced age discrimination in the last 4 years or they know someone who has. The impact of age discrimination is more than just financial. Older workers who think they are discriminated against are always so angry and hurt. Their personal identity is tied up in their jobs. But feeling like a victim of age discrimination and being able to prove it are two very different things. Proving age discrimination has never been easy, but in 2009, a U.S. Supreme Court ruling made it even more difficult. In the 2009 Gross versus FBL Financial Services case, the court changed the rules. Supreme Court Justice Clarence Thomas, a former Monsanto corporate lawyer, wrote in the majority decision that the employer doesn't have to show it would have taken action, regardless of age, even when an employee has evidence that age was a motivating factor in that decision. New legislation that would change burden of proof and causation standards for a number of employment discrimination claims was reintroduced in the House and Senate in July 2013. The Protecting Older Workers Against Discrimination Act would overturn two Supreme Court decisions that toughened the burdens of proof for employees bringing discrimination claims under the Age Discrimination in Employment Act or advancing retaliation claims under Title VII of the Civil Rights Act. In reversing Gross, the Protecting Older Workers Against Discrimination Act would establish that when an employee shows discrimination was a motivating factor behind a decision, the burden shifts back to the employer to show it complied with the law. In essence, a plaintiff bringing a claim under the ADEA would not be required to demonstrate that age was the sole cause of the contested employment practice. In a more recent Supreme Court decision, University of Texas Southwestern Medical Center versus Nassar, the court held that Title VII retaliation claims must be proved using a but-for causation standard as well. Under the standard of causation adopted in Nassar, a claimant must prove that the unlawful retaliation would not have occurred in the absence of the alleged wrongful action or actions of the employer. The Protecting Older Workers Against Discrimination Act would provide that the more lenient motivating factor standard would apply not just to ADEA claims, but also to retaliation claims involving race, sex, national origin, and religion, as well as claims brought under the Americans with Disability Act and the Rehabilitation Act of 1973. In a press release, Senator Patrick Leahy, one of the Senate bill's co-sponsors, said, "The Supreme Court's divisive holding in Gross has created uncertainty in our civil rights laws, making it incumbent on Congress to clarify our intent and the statutory protections that all hardworking Americans deserve. Our bipartisan bill reestablishes Congress's intent that age discrimination is unlawful, and it makes clear that employers cannot get away with age discrimination by simply coming up with a reason to terminate an employee that sounds less controversial." The older generation, those born from 1946 to 1964, account for the fastest growing segment of workplace discrimination claims. In 2012, 22,875 people filed age claims with the Federal Equal Employment Opportunity Commission, compared with 15,875 in 1997. Employers may think they can get rid of older workers and bring in younger, less experienced workers to save money without realizing that could constitute age discrimination.
Today, the Insider exclusive investigative news team goes behind the headlines in Justice in America, Dr. Robert M. Johnson's story, to examine how Ralph Wegis, founder of the law offices of Ralph Wegis, won a record-setting age discrimination case for Dr. Robert M. Johnson, an 85-year-old surgeon, for $20 million. After the California State Prison in Lancaster, California, where he worked for almost the past decade as the chief medical officer, forced him to retire in 2001, when he was only 81. When he refused, he became the target of retribution, harassment, and fraudulent complaints to the state medical board. An expert witness testified that despite his chronological age at the time of his forced termination at 81, he had the mind and stamina of a 55-year-old. The verdict set a precedent for age discrimination and sent a message to the public that older, more experienced employees and members of society should be valued and respected and not simply discarded like yesterday's trash. Ralph Wegis has earned the highest respect from citizens and lawyers alike as one of the best trial lawyers in Bakersfield and in California. His firm's goals are not only to get justice for his clients, but to make sure that everyone is treated with equal respect and dignity as guaranteed under the Constitution of the United States. Ralph has built a substantial reputation by consistently winning cases other law firms have turned down. His amazing courtroom skills and headline-grabbing success rate continue to provide his clients with the results they need and the results they deserve. This is the Insider Exclusive, live from Bakersfield, California. It is my great pleasure to introduce Ralph Wegis to the show. Welcome to the show, Ralph.
Well, good to meet you.
Tell our audience a little bit about your firm. What type of law do you practice?
My firm is a small firm. I have about 3 lawyers that work for me. And our practice is very limited. It's a litigation practice, and it's very varied. We work on under 10 cases at any one time. And the circumstances just occur that we get the gift of an opportunity to be involved in great cases.
You represent mainly the little guy, don't you?
I do.
Now, lawyers, when they graduate law school, they have choices, right? They can go to work for a major law firm representing corporations, but you stuck with the little guy. Why is that?
You know, a sense of freedom. Nobody tells you what to do. Nobody tells you how hard you can work, and you get to choose where you're spending your life and who you're spending it for.
You have taken on some major companies, and won. And you're up against some of the biggest law firms out there, right?
It's always the case, and you know, the thing they can't replace is they can't replace your passion for who you're representing, and they can't outwork you.
We're here today talking about an age discrimination case. When I first saw it, I was like, what? 80-year-old doctor, medical doctor, who was wrongfully discharged, fired, basically. And you won a $20 million verdict for him. Tell our audience who Dr. Robert Johnson was.
Dr. Robert Johnson is a phenomenal human being. He struggled through, as a Black man, through all the hardships that one can go through. And he had an approach to life that left him positive, left him contributing. And one of the things that he said is never suffer too long. And so what he would do with any hardship, he'd try to see the positive in it, move on. Just a person that went through medical school, went into the military, served our military for years, retired from the military, out in the practice of medicine, president of the Los Angeles County Medical Association, and through all his years as a surgeon, never a client complaint, never a malpractice claim, ever. A phenomenal man.
And at the age of, I think it was 72 or 71, he went to work for the California State Prison System.
He did.
Now, most people are retired by that time or think about retirement, but not him. He went to work as a chief medical officer at which prison?
at the Lancaster prison.
And how did that go for him?
You know, went phenomenal for him because he approached that by saying, I will come work in your prison, but I'm going to treat those people the same way I would treat patients that come in my office. What they're here for has nothing to do with me and nothing to do with the medical care that they should receive. So he was able to do great medical work and fulfill a great medical mission.
And that lasted until the age of 80, I believe.
That's right.
What happened at the age of 80?
What happened at the age of 80 is the state decided they were going to get rid of him for their own internal reasons of making places for their friends, I believe. And they called him in and they said, Dr. Johnson, you're over 80 years old. You should be playing golf. We want to throw you a big retirement party. And he says, I don't have any thoughts of retiring. And they said, well, if you don't retire, Sacramento's going to jerk your medical license. And he said, for what? And they said, well, we're keeping that close to our chest. So this meeting's ended then. The next morning, they called a medical staff meeting and they said to the medical staff, Dr. Johnson's been diagnosed with dementia and we need your help on reporting to Sacramento so they can take his medical license away. And that began the ordeal that became our case.
If I remember correctly, they started taking away his responsibilities, right?
They started taking away his responsibilities, changing his positions, and trying to ease him out that way, and he wouldn't take the hint. Instead of being negative about anything, he just took everything they dealt him and turned it into a positive and continued to deliver his medical care.
What finally happened?
Well, what finally happened is when they had that meeting and he went home and they called the medical staff together and they started a crusade to take his license away. And that was defended to a standstill. They didn't take his license away. And then we undertook this case for age discrimination for their treatment of him.
Now, at the age of 80, and I think it was 81 when he finally left the prison, at that age, it's a challenge to try and convince a jury that maybe it's time to retire. But your job, and what I admire tremendously, was showing the jury, because of the size of the verdict that actually came in, showing the jury that despite his chronological age, he was tested. You had him tested to show that he had the mental stamina of a 55-year-old, right?
That was exactly. And how you do this is you look for the truth and then you communicate that truth. And the truth of the matter with him is he has never had a flaw in his medical care of anyone. Now, what happened is a matter of science. You can test him for how his brain is working, and you can compare him scientifically to control groups of people that the brain is working perfectly in. And he compared at 82 years old, scientifically equal to a 55-year-old group of unimpaired doctors. And when you attack somebody for their age, the first place they go to is, oh, he has a bad memory. Well, on testing, amongst 55-year-old doctors, he was an all-star on memory. That was one of his strongest features. So that's what we were able to prove. And in fact, when the jury rendered its verdict, it rendered a verdict on the conclusion that he would have worked until he was 96 years old.
Right. So they gave, I have it broken down here, $1.6 million in economic damages and $18.3 million in non-economic damages for a total of $20 million.
That's correct.
Tell our audience a little bit about the jurors. What type of jury did you have? Did you have older people on the jury?
I had a mix, and it would have weighed, I would say the average age of the jury was 45.
Right.
And it's an interesting thing because when you talk about age discrimination and jumping to the wrong conclusions and discriminating against people for that, we're all going to face that someday. And so the jury, young or old, could experience what it was like and what it would be like if they were victimized by the same kind of misjudgments that are self-serving for somebody's selfish needs.
You bring up a very interesting point, and I'm going to ask you some just general questions. Age discrimination. Here you had your client who was 81 years old at the time that he was forced out, right? The jury came back and said, hey, it's been proven that he would have worked until maybe 96 years old because he just had those kind of genes.
That's right.
So what is age discrimination exactly, legally?
Well, it is where you're making a decision about somebody based upon their age. And this comes up most often in employment situations. And what it is older people are expensive, and sometimes there's economic pressure to cut the cost of employment and double up on hiring younger, cheaper people.
Was that the intent with the staff at the prison? They wanted to hire someone younger and cheaper?
I think it is not economically driven so much as it's an abuse of power driven issue. And maybe buried deeply within that, maybe there's somebody that has the power that's dealing with budgets and they think they can adjust the budget. But I think in this instance, the state jobs are good jobs. And I think you're looking at the job and you're thinking, well, I'm going to open up some places for my friends. And this is a political world, and I'm going to get rid of some of the people to make room.
Yeah, oftentimes when an employer lets somebody go because of age discrimination, they sometimes couch it in some other format. Like, for example, with Dr. Johnson, they all of a sudden discovered, supposedly, that he had dementia, that he couldn't do his job. And they were looking for reasons to let him go other than age discrimination. What kind of challenges for a lawyer does this present in trying to prove that an employee was actually fired or let go because they were too old?
The truth is your best friend, and you've got to do the work to discover it, and that's exactly what we did with him. We discovered the truth with him, as his mind was a great piece of machinery, and it had long life left in it to do the job he was trained to do. And everything that they used as an excuse and a diversion was a easy to use excuse, but on hot light examination was just pathetic.
Yeah, and probably I would guess working for the state or any organization, you probably have annual reviews, and his reviews were stellar.
Stellar.
Until the day they decided he had dementia.
That's right.
Wow. You did a fantastic job. As a result of that case, and I know it got a lot of publicity, do quite a number of people contact you regarding age discrimination cases?
It's interesting. There's no real rhyme or reason that we're a very small firm. We're very selective on what we do. And so we don't look for a volume of cases. And so it doesn't naturally spring from that case that other cases just like it come. But what I feel the best about that case is that we changed the way people thought about things. And what people would think is, what's the value of a case like that? And if it isn't valuable, you don't protect it. So they thought, no problem. Well, all of a sudden, when it becomes a $20 million value, people start having seminars on be careful, don't discriminate based on age, And so I think Dr. Johnson has, and a lot of other people that were a part of this verdict have made a big difference.
Right, and you did a great job because, as you just said, you put it in people's minds that just because you are chronologically older does not mean that you are not worth your salt, right?
That is exactly it. It's just, and it really taught me the evils of discrimination because it gave me a look at how evil that is because it's wrong and it causes massive injuries. That was a huge lesson I learned in this case.
Well, congratulations and thank you for being on the show.
Well, thank you.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.